Impact of Influence.
Covering true crime throughout the Southeast.
If you had condensed your theory of motive,
Right.
the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it.
That's some sound from the oral arguments arguing for Alex Murdaugh's appeal over the double murder conviction in front of the South Carolina Supreme Court. Hello, friend. I am Matt Harris. Seton Tucker next to me. If you want to join the conversation, it is Facebook, or you go to the YouTube channel and hit subscribe. But Seton, you were at this big deal, the big day in Columbia.
I was. It's the first time I've ever attended a oral argument in the Supreme Court. It was really actually very exciting and cool.
I would bet.
I'm going to go again.
And yeah, so it was crowded, full house.
It was a full house. I think the first people arrived at 3:45.
Okay.
And I talked to Melissa Gordon, who co-wrote the book with Neil, or whose husband co-wrote the book with Becky Hill. And she arrived at 6, and she said there was only like 6 people in front of her when she arrived. I got there at 7:30 and was easily able to get in. I think if you got there, they opened the doors at 8:30. I think if you got there by 8:30, you probably got in. But it was full, so I'm thinking maybe some people got declined if they showed up after that.
And you saw some of the old chums from the Murdaugh day.
It was, oh yeah, all the media that attended the Murdaugh trial were there. The Fitz News crew, Wall Street Journal, Dateline, HBO, John Monk with the State Paper. Jason, who is now back working full-time for the Post-Courier. He wrote the book Swamp Kings, and he was just a few people in front of me at the hearing.
You said law students?
Yes, I sat next to a really cool law student, and she wants to go to work as a prosecutor. And so she was actually really much more interested in listening to the evidentiary part of the arguments more than the jury tampering, because it's not as common for a court official to be alleged of having, improper contact with jurors.
I admit that I am very ignorant. I had no idea that you could just go to that courthouse and walk in and sit and watch the Supreme Court arguments.
I didn't either. And she actually told me that she does it all the time. She will go listen, and she sometimes brings work and sits in the back row and kind of does some work and listens to the arguments.
For those who didn't watch, now they were limited on the time, but the Supreme Court justices can ask as many questions as they want. So it was like a couple hours by the time it was done, right?
Yes, and it was, I think, much longer than the typical oral arguments. I think, when I went to the press conference that Dick Harpootlian held afterwards, he said that they didn't know until they got there that day. They were allotted 20 minutes to talk and on his portion, and that they received 5 minutes to talk uninterrupted before the justices could just kind of jump in and ask them questions. And usually that's shorter, so they felt pretty relieved that they got 5 minutes.
Sure.
But it's a pressure cooker. You can see the time, the time clock
and the lights
ticking by, and the lights, it's right there. And I can imagine that would be a very stressful situation.
Because you don't know what they're going to ask.
You don't know what they're going to ask. You kind of have to be prepared for everything and have to be able to pivot if they really want to go in a different direction than what you thought. And you're also really under this pressure, like, wait, am I not going to get into this point that I thought was a really good point I wanted to make?
It's not like you're doing a closing argument where you're just talking and talking and talking. I think it's two things very clear from people. A consensus is that the justices kind of hammered the state. Agree?
I think it was surprising that they had so many questions. To me, I thought that they would ask a lot of questions about the Becky Hill tampering and the logic that went into Toll's decisions. I thought that would be covered, but I didn't know that they were going to get into the evidentiary issues, especially the extent that the financial crimes came in. I did not know that they would question that as much as they did.
Or even the evidence. They talked about the phone for a long, long time.
They did.
Yeah.
And yes, and how that affected the timeline. And they seem to be very knowledgeable about little intricacies of the trial.
That's what I was going to
itself.
say. One of the second things that I think is a consensus as well is these justices knew this case. And it was 6 weeks. There's lots of papers and pages have been entered about the appeal. There was the toll hearing, and they were picking out things that you had to really kind of dig to know, right? And so I think that was impressive. But I guess, this is a national story. So
Well, they clearly did their homework.
But and I think the defense, Creighton Waters, was kind of taking a beating. And whether it's his fault or not, it seemed like the Supreme Court justice, we all agree.
Becky Hill is not on him. I mean,
Yeah.
he could not have predicted that was, going to come his way.
But it was
And he,
rough
I
day.
said it to my dad. He's almost had to act in kind of a defense attorney capacity to defend Becky Hill's actions.
And well, I mean, Justice Toll took some shots in there too. So it was. I didn't go the way a lot of people expected.
No,
when you read what attorneys were saying, people we've had on,
and when you listen to, I haven't listened to really. I've only listened to one talking head, but it definitely seems like the consensus is people thought that it was a good day for the appellant defense and not so great of a day for the state.
Now, I talked to Joe McCullough afterward, and he said one thing to keep in mind. Yes, it does seem like it was a great day for the defense. He says, but I've been up there before, and I've seen the times when it seems like the justices love you and love your case, and then next thing you know, you're like, what?
What
How
happened?
did I lose that? Yeah,
As
how
I
did
thought
lose
it was.
that? Yeah.
Oh, it's just like you go in for that job interview and you think you did so great,
Nailed it.
and then you're like, wait, they never called me back.
Right. Yeah. Yes, exactly. So we shall see. But now let's dig into it a little deeper with your pops, the professor. He is back, the professor. Matt Siembieda also happens to be Seton Tucker's father, and we've had him on the show many times. Went to Penn Law School, professor at Temple. He's been in front of appellate courts and Supreme Courts, and I believe he clerked for a Supreme Court justice at one point, correct?
No, I clerk for a Third Circuit
Circuit
judge,
Court.
Circuit
yeah,
Court.
Okay.
which is the appellate court right below the U.S. Supreme Court.
Right below it. Okay. So you knew how this works, and you were right on a lot of things that you had predicted, like time and how it was going to work and how you would be able to pick up a vibe based on the questions that were being asked. So do you want to start with that, Seton?
I do. I mean, first I want to say it was a packed house.
Seton was there, by the way.
I was there. I saw it was 3:45 a.m. The first people got there, but I got there at 7:30ish, and I was easily able to get in. The doors open at 8:30, but it really was, every seat was taken. So there was definitely an interest, and I met some law students. That was pretty cool. And some pre-law students. They did a field trip from Clemson.
Great.
Yeah, that's
So I
cool.
thought that was
Yeah.
cool. So I want to start off, the judges seem to ask really pointed questions. What does that tell you?
Well, what it tells me was several things. One, as Chief Justice Kittredge indicated when he became a judge, he wanted to create a very transparent, open, collegial court system of some sort or another. And it was very apparent to me that both the way the judges interacted with one another, clearly they had all prepared, and I think they had discussed the case, which is appropriate, even before they got on the bench. I think that the degree of decorum in the court, the way they treated the lawyers, the way the case proceeded, the way they allocated time with 5 minutes initially to talk about what you want to argue, and then the rest of the time during each arguing person's time was allocated to questions and argument, I thought was very interesting and very good. In terms of the actual hearing itself, I thought that there was what we call a very hot panel, which means that they are deeply prepared, deeply interested, and want to ask questions. I counted, and I took detailed notes, over 10 pages of notes during the argument. And what I noted was that there were at least 45 times during the arguments where the justices asked questions. And there might have been multiple questions within those 45 more times, which is, I don't want to say unusual, but certainly shows a very prepared court that was there. Most of the questions, a lot of them were asked of Mr. Waters, and for the and about the state's case and the way that had proceeded. So, and I think that gave a huge tell. The other thing that I noticed was both the reactions of the judges during the argument, as well as the reactions of the people who were making the arguments, which we can talk about a little bit if you want. And I think they gave you some sort of tell as to which way they felt the arguments were going and what was taking place in various ways.
Okay, so before we start on anything else, I was surprised, like you said, about how many questions and how engaged these justices were. What did these questions that were asked tell you?
It told me that they were most concerned initially about the tampering issue. So, for example, Justice Kittredge asked a series of questions to Creighton Waters about that tampering issue, and in particular, questioned the way, the fact that the clerk was what I believe was called a rogue clerk, and acted inappropriately. And it was a whole series of questions by Justice Kittredge, said in a very forceful and meaningful way from his point of view, as to what he thought was a huge problem or issue in the state's argument, in the state's case to hold the verdict below right now.
Okay, so let's this is part of that question and answer.
Assume that statement was made. Do you still have a path to victory?
That don't be fooled.
At the end of the state's case, before the defense presents its case, the statement was made. Do not be confused. Do not be misled by defense and its counsel.
Right. Well, I would say, and this is like everything in this, it is a question of degree. Okay. And there could, if the clerk had come in there and held a gun to their heads and said, you better vote guilty or I'm going to shoot you all, I probably wouldn't even be arguing that's not structural error. Okay. But everything is a question of degree. I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But I think you have to look at that in the context of this entire trial and when those particular statements were made.
Right. And I think context is important too. We all can cherry pick some of these that are on the surface innocuous. Epic day, big day. And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
I could not argue otherwise, that would absolutely be a question of degree. However, I don't believe that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things and let's assume that we're limiting it to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying watch his body language.
He actually goes, the justice, as far as going, say, nefarious, using that word. And it appeared to me Waters was on his heels with trying to answer that. And one of the things he says is, you got to take it into account how long the trial was and when it happened. But they didn't seem to be having that.
Right. There are several points I'd make with regard to that. One is, the judge basically, Justice Kittredge, basically said, well, listen, some of the comments that were made by the clerk, might have been harmless error. But certainly the comments about don't get confused that were made to the jurors that were collaborated in a number of ways were very, very important. And basically he challenged Waters to say, why isn't that enough to give Alex Murdaugh a new trial? And I thought that was very telling the way it happened. The second point is you ask about Creighton Waters' reaction to it. It was clear that as this evolved through the argument, that he could sense that the case wasn't going well for him. You could see in the pace of his voice, you could see the fact that he started to wander around the podium a little bit. I've seen that in other appellate arguments I had when it wasn't going well, and you get that body
Have you done
language.
that? Have you done it?
No, I had a case once that I won in Chicago on a constitutional issue before a very good panel. And during that argument, I had lost below, so I was the appellant to the Seventh Circuit, and we were arguing in Chicago on it. And during it, and one of the judges on that panel was Judge Posner, who, at that time, and I still think is considered to be one of the great circuit court judges of all time. And what happened was I made my argument with a few questions, but not many, and sat down. He got up, and immediately Posner started going after him, asking him a bunch of hypotheticals. And you could tell he was getting more and more stressed by it. And at one point, Posner asked him a hypothetical that he had to answer, yes, that's correct. And the judge said, that's why you lose. And the guy
Oh,
started
jeez.
literally shaking and moving around the podium. In fact, it got a little nervous because the judges looked at the marshals in the courtroom in case the lawyer started making moves towards the bench, which he wasn't. He was just nervous. And you could see the marshals stand up in the background when the argument was going on. Long-winded way of saying that I saw some of that same reaction, maybe not quite to that degree, but some of that reaction by Creighton Waters during the argument. As I said, he spoke fast, he started to move, his eyes got wide, his pace picked up a lot. He did the best he could with what he had to deal with. He quickly tried to pivot to the suggestion that, 11 jurors said there was no issue, only one did, and that person, he tried to challenge the credibility of that witness, and that's when all the justices started to challenge him in various ways through the argument about, even if one heard these comments, that's enough. Two, that there was some collaboration by the alternate juror, by Juror Z, by the Egg Juror, by the comments made to the other clerk that was there, similar to what the people said in terms of the comments that were to be made. There was also suggestions about the motive of unfortunately, of Becky Hill to sell books and to profit on what had taken place in the trial, and her comments to the effect that she had the best chance of making money on the trial if, in fact, he was found guilty, to the clerk, to the other clerk that was there. Long-winded way of saying, once again, that all those things give you a strong indication and showing, particularly with virtually every other judge asking similar probing questions about the tampering issue, that I think that it's highly likely that the court is going to give Alex Murdaugh a new trial on that.
Well, let me ask you, were you surprised at the egg juror kind of coming into play so much during this hearing? The justices asked about the fact that the egg juror, Myra, was not heard during the evidentiary hearing, but we did hear from the alternate juror why, and then also whether that they could consider her affidavit as part, and I think Waters maybe tried to challenge some of her credibility because she was dismissed. Was that surprising to you, and what do you make of the justices really kind of looking into the egg juror?
Can I ask one more note on that, which I did not know until this, that they pushed, was that her affidavit is in Justice Toll's record. It's in the record.
Yeah.
Which was probably an important thing. Waters kind of seemed to like, I wasn't sure he even knew it was in there, because she doesn't reference it in her ruling.
She doesn't reference
But
it
it's
in her.
in-
It is in there, and in her affidavit, it says recants this conversation about Becky Hill asking her what her thoughts are on guilt or innocence of Alex Murdaugh, and she says she's undecided. She's not sure. She has some questions about guns and some other things. So it's pretty significant. Her affidavit is pretty significant, and so I think that her credibility as well as Z's are going to be really important things in this ruling.
Yeah, I think that that's correct. In fact, the first question asked by any of the judges during the argument yesterday was by Justice James, is my recollection. And he asked Mr. Harpootlian about was the egg juror's testimony considered by Justice Toll. And it was at that point, as you rightly pointed out, that it was that he said that the affidavit of the egg juror is in the record and therefore theoretically was what should have been considered. Justice Kittredge then filed up and said, do you think Justice Toll considered it and rejected it? And there was some discussion around that particular issue. Was I surprised by it? No. But if what I found over time is that if the court and the judges or the justices look at this issue, and they have a very strong belief that something is wrong, and that something happened, they're going to look at the entire hearing and the entire atmosphere around it and all the witnesses and come up with that. And clearly, they all did their homework and realized that the egg juror had some crucial information, particularly as set forth in the affidavit, that should have been considered and was supportive of Juror Z and the other information that came in around the conduct of Becky Hill.
Well, because it was the same wording that
they bring that up many times. That Rhonda McElveen, the clerk of court from Barnwell who assisted in the trial, she says something. She recounts in her testimony at the evidentiary hearing some very similar comments that were heard by other jurors.
Which is watch the body language and don't let them fool you.
Well,
these kind of things.
I don't think Rhonda McElveen says don't let you fool you. She says, today is going to be a good day. A big day. Watch his body language.
Yeah, watch the body language.
The don't be fooled comment was something that Juror Z says. So I feel like that was kind of something that was being, that was kind of a crux of it. I think Creighton Waters is saying they're just very innocuous comments over the course of this 6-week trial. Stuff like today is going to be a big day. Everybody would know it's going to be a big day because Alex Murdaugh was going to testify. So he kind of tries to minimize these comments where, it says was such a long trial. Now the justices, we have two things to ask. The justices are questioning, like, do we have a different standard over long trials versus short trials? Yeah. And also, the comments about the don't be fooled comments, which weren't heard by all the jurors who've said this. I think Z, Myra, and the alternate have said that.
Yeah, I think that it was Justice Kittredge tried to parse it out. And he said some of the comments were, maybe you shouldn't have made them, but I don't know if that's enough. But certainly, as you rightfully say, the one that said, don't let them confuse or fool you, was quite significant in Justice Kittredge, and I believe the other justices' view with regard to that. The other point I would make is it was interesting. Below there was a lot of discussion of Justice Kittredge's decision in Green and Remmer and all that. And the third question asked was by Justice Verdon. And when she asked her questions about that, basically the answer by Harpootlian was that they were consistent. And there really wasn't any pressure from any of the judges, which was basically the gist of what the state had argued below and what Justice Toll, to a certain extent, had relied upon in her decision. And basically they said, yeah, there's nothing inconsistent about all that. And which I thought was another big tell in terms of the way they were going to go. If they were going to go in favor of the state, I think there might have been a lot more pushback or discussion or argument around that issue.
Did you think I thought this was interesting, but you have a better insight. I forget which justice it was talking about the fact that these comments were about Alec testifying. And he said, given the lack of evidence or the evidence you were trying to piece together, when Alec is on the stand, it's very simple. If he's lying, he's guilty. And if he's telling the truth, he is not guilty. So therefore, any comments about, which is basically the real thing about that the defense is submitting. So no matter how long the trial was, that was like the most important thing that Becky Hill commented on.
Yeah. I mean, you're right. And I'm looking at my notes. I can't find it quickly, but you're right. One of the justices queried him about, the key thing when he got in the stand and testified really went to his credibility, and credibility meaning did he lie or not lie, and to the extent I think what you're getting to that they that you had Becky Hill saying don't be fooled by him, and then the fact going to the next second stage of the argument about all the evidentiary evidence about financial misdeeds on Alec's part, all those things contributed to it. And he basically challenged Waters pretty much in terms of, gee whiz, should you have been allowed to do all that and get into all that information?
Well, before we get into that, because that was also a big thing about the admitting of the financial evidence to the extent it was. Before we do that, one thing that they brought up is these affidavits and the testimony of Juror Z and the alternate and the egg juror, and they say, part of it with Z is you can't really discuss what happens during deliberations. That is not something you can discuss. So Harpootlian talks about you have to use the standard of this kind of hypothetical juror.
Mm-hmm.
Explain why that is. Why and how that would kind of play into this situation.
Let's play a clip first to get us a vibe on that.
606B, he says it's not raised in this case, but should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So
that's an interesting point, because Rule 606B says that you can't consider the effect of something on jurors, because otherwise you're invading the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden, where a deputy says he's an evil fellow and he's guilty,
right?
They say you can't rebut that. That's not rebuttable, and so he gets a new trial.
But in Parker versus Gladden, they talked about the prejudice.
Well, it's the prejudice is apparent if you use the standard some of these cases use, which is the hypothetical juror. Would it objectively influence the hypothetical juror? I mean, I think that's what the state has to do, is say these comments would not affect the hypothetical juror.
But all right, so what do you think about the hypothetical juror?
I think the hypothetical juror basically means that a juror is supposed to be pure and not influenced by any outside influences, such as the statements of the clerk of the court, don't be fooled, and things of that nature. And I think that is key. By the way, if I could just go back 1 second, when you were asking me about those questions about Alex, I think it was Justice Few from my notes seemed to be the one asking those questions. And he asked it in the context of the state has to piece together evidence about Alex, and what Alex has to say is when he gets in the stand that he's not guilty, and it all comes down to whether or not he lied or not. And that, Becky Hill saying that he's not credible goes to the heart of that, is what it.
Yeah, it can't be a fleeting comment if you're talking about the most important part of the trial.
Exactly what Justice Few was saying. Exactly.
Yeah. Okay.
Okay, so back to the credibility of how, I think questions were made, that Toll didn't really go into the rationale of how she assigned credibility to Hill, Toll, or Hill and other, Z and the Egg Juror. And there was a specific time where one of the justices were talking about Z's affidavit. And they're like, okay, Z's affidavit, we're supposed to believe these things, but not these things. And how can we carve out what we believe and what we don't? And can we consider that? What did that tell you?
Well, what that told me was what the court was saying was that Justice Toll picked and chose to suit the result she wanted, what she was going to take out of the affidavit. So she took the things that supported it and things that didn't support it, she said were not worthy. And I think the justices were going to that. It's all in or it's not in is basically what they were suggesting and saying. And I think that's a good way to look at it.
I mean, it seemed like they were coming hard on her on how, because they said multiple times, why is the egg juror not, and which all of us said, lay people, why is the egg juror not testifying when an alternate is testifying who didn't have anything to do with it?
Exactly. And the other thing that they mention is this kind of overwhelming amount of evidence, which Toll references as well as Newman in his final statements at the end of the trial. And the question is whether the overwhelming amount of evidence matters in this case.
And it really doesn't. What really matters here is whether or not he got a fair trial. And if he didn't get a fair trial under our Constitution, he's entitled to a new trial. And as we've said in other podcasts, obviously was a lot of strong circumstantial evidence against Alex that came out through the trial in various ways, particularly by way of example, the phone video that was recovered from Paul's phone at the kennel, and Alex originally denying that he had any interaction with him around that time. And that is very strong evidence that could be used. So that, so I understand the strong feelings about it. And then you couple that with the large amount, and I think the court viewed it, and we'll get into it in a little bit, the overuse of all the financial information that came out with regard to that. All of that creates a strong view and reaction from people that Alex is guilty. And maybe he is. But he's entitled to a fair trial to put on a defense and to see if he will win. The other thing I would say to a comment that you made was that I think that Creighton Waters tried to argue to the justices that the egg juror did not go into deliberation and therefore what she said shouldn't be considered.
Right.
And what they said is, well, one, it's consistent with what you heard from Juror Z and the alternate juror. But two, the alternate juror didn't go in and Justice Toll considered that. So therefore,
Right.
the egg juror's
Right.
testimony should be considered.
Yeah, we brought that up multiple times. Like, why did we hear from the alternate and not from Myra? And I think Waters kind of responded saying that Myra, the egg juror, was dismissed for legitimate reasons. He said that it was found that she was talking about the case outside of the court, despite saying she had not. I still have questions about that. I want to see, because I have found her to be pretty credible along the way, and I'd like to see those SLED interviews.
Yeah,
Yeah,
absolutely.
they allegedly
Uh,
interviewed a serviceman on a refrigerator, said she was talking about the case or something. I like to see those interviews and what took place there.
Yeah, absolutely.
Yeah.
Okay, do you want to move into financial now?
Well, the one other thing I wanted, I would love to play, before we move on from this credibility issues, one of the judges actually talks about Becky Hill's testimony and says Becky Hill is not credible at all because she's a liar. Like, they go
yeah,
as
that's what it
far as
was.
saying that. And I think, I sympathize with Creighton at this point because I thought that he was really having to almost serve in the capacity of a defense attorney towards Becky Hill.
Yeah, he was on the ropes. There was no question.
Yeah. And and as we said, when I'm looking back at my notes, as you go through each one of the justices, particularly at the end of the examination of Creighton Waters, and I have Justice Few, I have Justice Kidridge, Chief Justice Kidridge, I have Justice James, Justice Hilligan, Justice Kidridge, and I'm sure Justice Verdon was in there at some point, were all challenging Waters in various ways about the importance of the clerk, the importance of her position, the statements that were made about the credibility of, as you said, the Z juror and the egg juror and the alternate juror and the previous statements to the clerk. All those seems to go to the heart of what was going on, which was basically the strongest point being the comment, "Don't be fooled." And they were all pressing very hard at the end of Waters' argument on that particular issue on the tampering stuff.
And we should note, to be fair to Justice Toll, she did not have the full knowledge of the investigation that had occurred. The investigation into Hill happened after this evidentiary hearing. So when she made her ruling, she did not know everything that we know at this stage.
But it does not excuse the egg juror who was outside the courthouse could have easily been called.
Yeah, that confused me all along, and I've said it.
Yeah.
Just one more point, on the tampering issue. It's interesting in the reply argument by Mr. Barber, there was only one question, I think, asked by one of the justices about the clerk of court stuff and the tampering at any time. And I think it was by Justice James, I believe. And therefore, that tells me that by that point, on that issue, they had made up their mind.
That's what I was
Yeah.
wondering. I was just about to ask you that question. Does that indicate to you that there is some sort of decision, already in that realm?
Or they just decided, okay, we've handled this one. We're going to go to this one. We're going to go to this one.
Or they felt like they've received significant,
Information.
response
Well,
to the.
remember, this is in the
questions.
rebuttal part, the last 5 or 10 minutes that Barber had, and all the
Okay.
questions were really around the evidentiary issue.
Yes. It was all about evidence, basically.
Yeah.
And financial,
Yeah.
which is part of the evidence. Yes. So along those lines, the financial issues, again, Waters seemed a little bit on his heels again from this.
Jim Griffin covered it initially. He gave a spiel of why he thought that the financial crimes, the motive was he didn't see the connection. Did you think that Jim Griffin did a good job making the argument that the financial crimes really didn't make sense as a motive?
I thought he did a good job in his argument. I was a little surprised when he outlined the evidentiary issues. I think he outlined it, the cell phone stuff, the raincoat, then the financial crimes, then the Miranda warnings, remaining silent, and expert stuff. I thought he should have led
firearm
off with the
testimony.
financial crimes, because if anything seemed to be quite aggressive and lengthy in terms of what the overall issues were in the trial, was the amount of time that was spent for a number of days and a number of witnesses on the financial crime stuff.
I think that is actually the perfect time to listen to a clip, because one of the justices addressed just that, said this could have been covered in an hour and a half instead of, multiple days of testimony. I think we should listen to that clip.
If you had condensed your theory of motive,
Right.
the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it.
It was long testimony. And they get in that with later. Barber really went down the path when he got up there about the testimony not being about the financial crimes. It was always about a theme that he said Creighton Waters had, which was asking everybody, did you really know the real Alex Murdaugh? Do you really think he'd be capable of that? Look at the kind of people, like a disabled person. It was
Tony
not pure money.
Tony Satterfield, basically Tony Satterfield testified, and during that testimony, he's asked about his brother who has special needs, and multiple justices asked the question, like, how is that relevant? Maybe we should listen to that clip.
In June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case. I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes. And that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you, I'm going to take care of you, one of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief and that was the motive for doing it, this extraneous information that tugs at your heartstrings is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself.
Right.
Not this extraneous stuff of every granular detail
Yes, sir.
of his acts of theft.
What do you think about how the justices seem to go after, well, it is presented first by the defense, that a lot of this financial stuff didn't tie directly to a motive, because they talk about how some of the financial stuff went back 6 years.
Yeah, I mean, it was clear that I think what Waters was trying to say is that somehow Alec was in a bad way because of all the stuff that had happened. And that in an effort to try to divert attention away from that and give himself more time to recover, he killed Paul and his wife. I think is what he was trying to say in what he was trying to do. He didn't quite say it, I don't think, that directly or succinctly, but I think that's the argument that he was trying to make. I think the court just thought it was over the pale, and based upon the parts that you played, it's clear that judges thought that there was just too much of that came into the record. And not only that, but going into the Tony Satterfield and some of these other things which simply done to inflame the jurors, to paint Alex Murdaugh as the most evil person of all times, so that they're more likely to find him guilty of murdering his wife and son than before. Because let's take a look just for a moment about how this case evolved. The government actually had a fairly tough case to prove, but the government didn't have a weapon. They did, from all outward signs, there was no adversity between Alex and his son or his wife. That
No DNA,
or DNA.
eyewitnesses.
There was a very sloppy investigation, it appears, done by SLED in terms of not getting tire tracks, maybe not getting not searching the house.
Or even time of death.
The time of death, yeah. There was all sorts of things like that they seem to be very critical of SLED, and maybe rightfully so. And so the state had a pretty difficult case. No weapon. All these things happened. The best thing they had going for him, I think, was Alex denying that he was at the site shortly before they were killed, and then sometime later they were able to restore the video that showed it, that he was. Now, interestingly enough, if to listen to that video, it wasn't like Alex was in any sort of confrontational way with Paul or anybody else at that time. He seemed to be like a normal conversation. All that being said, he clearly was there shortly before they were killed. That's the most and strongest part of the case that the state had. Clearly, the state felt that they needed more. So what they needed to do was establish a motive. And by establishing a motive, the strongest point to establish a motive was all these financial crimes that Alex created. And along the lines to show that he was simply trying to buy some time to cure all the wrongdoings that he did, and therefore he took the awful act of killing his wife and son.
There is some questioning by some of the justices about, hey, was there ever any evidence about Maggie being onto these financial difficulties? One of the justices, I guess there was a bounce check, but
Or also Paul. Remember they said Paul being the
little
investigator.
little detective or whatever. So Jim Griffin responded that There was really no evidence that Maggie knew or she was about to turn him in for any of this stuff, or that Paul knew anything other than Alex drug usage. So they did ask that question. So maybe, but we don't know. I mean, they're no longer here to tell us. Maybe they were on to him, and maybe that what that. I mean, I thought that Creighton actually kind of did a good job saying that you have to connect all of the dots to be able to understand the big picture, that there was
boiling.
that there's a simmer, and you have to see the simmer to understand the boiling point. So I did think that he did a good job kind of trying to articulate why it was so important to present the amount of evidence that he did. Now they did question that whole like what did the fact that Tony Satterfield's brother that you stole from a disabled person, yes, that makes you look worse. So like you're saying, when you're asking these questions like, did you really know Alex Murdaugh, or those type of things, I think maybe was the amount, maybe
Too
I think it
far.
was called a waterfall fall. Was that unfairly prejudicial in your opinion?
Yeah, and in fact, I think, from my notes, I believe it at one point, Justice Few said, wasn't it unfairly prejudicial, the amount of time and effort that was spent going through these financial crimes to Murdaugh? And you're right. I think that Waters, did a really strong job in pointing out this boiling sort of argument he was making, that he got to the point where he had to do something. But I think the court thought it was just too much, and it was unfairly prejudiced to him. Um, I thought going into the argument, it was more likely that they were going to seize mostly on the tampering stuff, but it didn't surprise me. They also seized upon the amount of financial crime stuff that was let into the record here. Um, I thought they might avoid it, but clearly they thought it was significant enough to bring it up. And I think part of the reason is let's assume that they send the case back for a new trial. They're basically trying to send a sign to whoever tries the case. I know Judge Newman's retired. Whoever tries the case, they have to be very careful about what other information they let about Alex come into the record to make sure it's not overly prejudicial and he gets a fair trial.
Well, we all kind of think that maybe we're leaning towards a new trial based on this jury tampering, which is no fault of anyone else but Becky Hill. Um, you know,
Uh,
I guess the prosecution, when they make the decisions about how much information they're going to present, so that is slightly on them.
definitely.
Do you think that do you think that they will err in favor of a new trial based on the financial as well?
I think they're going to try to carve it close to the line and try to get in as much on the financial crime information if possible, if they can. I think from the Murdaugh side, they're going to try to keep almost all of it out, if not all of it out. And the way they're going to try to do that is limit what they do get into Alex Father of the Year sort of comments, and limit that. And they're going to try to limit it basically to what happened around the murder scene. And the state really doesn't have much to show that Alex did not get along with his wife and his son. And so that then gives the defense the ability in their closing argument to say you heard nothing from the defense to show any adversarial relationship or any, any bad situation between them that would cause them to kill them. So if it's presented right by Murdaugh, they can limit greatly. Now on the state side, what the state is obviously going to concentrate on is as much that they have any scientific evidence, which they didn't seem to have much the first time around, as well as that video and a timeline to show that, Alex had to be the one that did it. That's what they're going to try to show. It's going to be a tougher case for the state the second time around, that's for sure.
Well, it's more like when they're saying all about the financial crimes being, is it really the state's fault or is it Judge Newman for allowing it? If they're going to allow it, you maybe as a prosecutor, you're like, well, they're going to allow it, I'm going to do it.
Well, yeah, but at the same time, usually in these criminal cases, there is a great deal of rush to put in as much information as you say that the court and the system will let you get in that is helpful to your case. In this case, in this situation, I think that it was incumbent upon um, the state to realize that enough is enough at a certain point.
Like they were winning. They were winning. So maybe if they had been a little bit more judicial in what they presented, this would not have been an issue.
That's right. I mean, it's like an SEC football team playing a big game and they're up by 40 points and they keep their starting quarterback in and he gets hurt at the end of the game.
That's exactly it. Yeah, 100%. Like maybe if they hadn't gone as far as putting Tony Satterfield, they would have limited it to just a few witnesses to kind of get the point in that this was the motive. But then I also get that it was far reaching with all of these financial crime victims that they really wanted to make sure people knew the mounting financial pressure that Alex Murdaugh was feeling.
No, I think,
Yeah.
I'm sorry.
No, yeah. I mean, she's right. That mounting pressure, because even at some point, he brings up Family Annihilator, which is somebody who snaps and kills their family. So there was that was in there.
Right.
So
No, you're absolutely right. I mean, I think that was probably one of the stronger points of Waters' argument, as both you and Seton pointed out, in terms of this whole boiling situation and all that. But with that said, I think the court viewed that it was over the top.
Oh, I think it was funny because at one time, I think I have this right. One of the justices says to Waters, "Can you tell me anything that you wanted to put in that was not put in?" So it, like every single thing he wanted in got in. He didn't even have an example.
There was one example. The only example was they wanted to get some testimony about marital problems and a possible, affair.
Oh yeah,
And
but that's a bounce check.
But that was literally the only thing that did not come in. And I think in my mind the big question is was that kennel video putting him there, was that enough for a conviction? Maybe that they did need some evidence of a motive
Oh, they did.
to get this conviction.
Right. And I get why the state did it, and you make an excellent point there. The question is did they go too far? And let's just talk for 30 seconds about how that evidence even came in. I believe originally Justice Newman was not going to allow any financial crime information in.
He said no.
Limited, very limited.
No. He said no. He said no.
Yeah. And what happened?
He said no until Griffin opened the door.
Yeah,
right?
Griffin asked, I think, a friend of Paul's on cross-examination, basically what was his relationship with his dad and what was the dad's relationship with his wife. Yeah. And that was enough. And I think the answer was, it was great, or something to that effect, that the state argued that was enough to open up that whole area. Was it? You can go both ways on it. Off air, I discussed it with Seton. I think it's a close issue. Seton thinks it was probably right. But
I mean, because if you present evidence of good character, then you can present evidence of bad character. I mean, I'm no lawyer, but that's just what my understanding of it was.
Yeah. And the question then is, I guess my biggest struggle with it was it just went too far over the top through the trial.
You had one sentence from one guy, and then you had 7 days of bad character.
Yeah. And then when Alex was on the stand, I mean, basically, I think you raised an excellent point, Matt. I think there was a whole series of questions that were asked Waters of Alex about, how he had basically abused all of his clients. And it was just so over the top the way all that proceeded and all that happened. And candidly, but for the fact that Griffin opened it up on the character side, Alex may not have even had to testify.
Right.
Well, that's a question for you, is if he does get a new trial, would you expect them to try to avoid putting him on the stand?
It's his right to decide that himself, not the lawyers. But if I was his lawyer, I would strongly suggest that he not. He did not come across well. And I think all those things, lead you to the conclusion it's best he doesn't. I think, as I said, that the best argument the state has is the one that Seton just said around the kennel video. The question is that enough? On the Murdaugh side, they're going to basically try to keep out during the evidentiary part of the case anything about character information and try to limit the state in what they can put on about character information. If they are successful, Alex doesn't go on. It simply comes down to them being able during the closing to say they had no information to show that he had any bad relationship with his wife or son or any real motive there. And the state's going to come down to arguing, hey, listen, he lied, and it was shortly before the killings, and there's a video to show that he did it, and a jury may very well conclude that he did. But there's certainly going to be a lot of stuff that can be created, and it purely is at that point, a circumstantial case, which it always has been. It's going to be tough.
Is there anything in the evidence that stuck out that you think might hold? Because they talked about the phone stuff for a lot.
The flipping, the flipping phone, and they did
I
talk
don't
about
think
this
the
timeline.
state's not going to put that back in again. I don't think that was sort of silly evidence. I thought at the time when the guys,
are the justices going to use that in their decision, or is that going to be kind of an afterthought?
I think they're going to sort of avoid everything other than the financial crime stuff.
Okay.
And the
jury.
the champion.
Yeah, there was a little bit of discussion which I didn't fully understand. I had to go back and look at the record around the cell phone.
It's a timeline. I think
yeah.
I think arguments can be made on both sides, but I suspect if there is a new trial, that will be something that will be looked at very closely by both sides.
I think the defense did a much better job explaining the timeline in this trial than they did in the other trial.
And when they brought Barbara back during the rebuttal, that there were questions about this timeline and the cell phone data and the flipping of the phones. Yeah. They were interested and they're looking at that.
Yeah, and he was very strong, I thought, Barbara, on that, pointing out that the timeline didn't really support him. I think what he was saying was really didn't support him killing Paul and Maggie. I just don't know enough of the timeline to fully analyze that. But that's clearly going to be a huge part of the defense and the prosecution the next time around. You're right.
If there is a next time around,
okay. So give us your predictions. Do you think that the Supreme Court's going to rule one way or the other?
Well, I think there's a couple ways to look at it. One is I think that he will get a new trial based upon the tampering issue. And I think there's going to be something said about the degree of financial information and maybe something about the cell phone. The other stuff will probably not have really any play in it. And then the second part is, will the state really retry him? Because right now he has a 27-year state conviction and a 40-year federal conviction, which means that he would be close to 100 years old if he was able to get out of jail anyways. Is it really worth the state taxpayer money to do this? I don't know. I mean, certainly if someone commits murder, that's a very serious business, so maybe the state would. I know it's been a little political in the state between some of the candidates who are running for governor about the quality of the state's attorney general, and this could hurt his chances. So maybe he's feel compelled to press the case to go forward. So there's going to be a lot going on. My bet would probably be that it would go back for a new trial and it would try, but there's a chance that they may decide he's going to sit in jail the rest of his life anyways. Why retry the case?
Well, and his family, we don't know for sure. We can't speak for them, but they may not want to do this again. And don't they consider what families want to do in situations like this?
They should. I'm not sure the state's going to consider very much what Buster Maddox and his brother and the others may want, but they should consider that.
Okay. Oh, and also just one of the.
Oh, wait. The other option, too, though, is they could also remand it back for a hearing to kind of delve into these.
Like a Remmer hearing type thing?
Right. Could they, I mean, do you think that could be another possibility that is considered?
That's certainly, I mean, the three possibilities, you're right, is one is send back for a new trial, send back for further hearings, or dismiss the appeal. I think that I don't think they're going to dismiss the appeal or affirm. I think that they're probably going to give him a new trial. I don't think they're going to send it back for a Remmer hearing. Remember, as I said, there were very few questions asked about Remmer and the standards there. I think Justice Verdon asked a question early on, and other than that, it might have been touched on lightly once or twice, but not
Yeah.
much.
How long do you think before they rule?
They seem to be fairly well coordinated in terms of, we're just watching the bench, when they got to the red light part, and some of the lawyers, particularly Creighton Waters at various times clearly wanted to sit down, that he looked around. Well, I think that so-and-so may have a question or so-and-so.
Well, and we should, in his defense, on the defense team or the appellant, they had 3 lawyers arguing each point.
Yeah.
Each section.
Yeah.
Creighton Waters did all 3 himself. And, I think what I've been
Yeah.
told is it was a lot longer than the typical Supreme Court oral arguments. That had to be very stressful. And you're sitting there with this clock and it was just him.
No, I agree. And, in fairness to him, I thought he did, with what he had to work with, a very good job. I think you're right that, the arguments around, the boiling point were pretty good and pretty interesting. And some of the judges reacted favorable when he made that point in argument, or at least, addressed it further with him a little bit. I thought that was good. And listen, with the hand he was dealt with, I thought he handled it pretty well and argued it pretty well. I think he did a good job with all that.
Yeah, he just didn't have a good hand.
He didn't have Becky Hill.
Yeah, well, and it wasn't his fault. You're right. It was, Becky Hill. I mean, the only thing you could question him a little bit about was that he put in too much financial information. But I mean, most lawyers would do that. So you really can't be all that critical of him for even doing that.
Even critical of Justice Toll, I think it's fair.
I think they
He also did not have all the information when she made her ruling.
No, but she still could have had the egg juror.
Yeah.
I agree with that.
So that's what
I
I'm saying.
question that. I'm like, why
Yes.
on earth would she not want to hear from the egg juror?
Yeah. So I think that's fair criticism of her.
I agree. I do feel like that is fair criticism, and I don't know what the rationale. I'd love to, Justice Toll, if you want to come on and tell us, we'd love it.
Well, and they came pretty close to being critical of Justice Toll's approach to it.
Yeah, I think so.
Yeah, which was a little surprising to me. That was the only part that was a little surprising. But, I guess in order to come to the conclusions on tampering that they were coming to, I guess they had to reach that level. So, I mean, I understood where they were coming from on all that. That makes some sense. You had asked me something, Matt, and I might not have fully answered your question. Did we start down this path?
Was it how long before they...
Yeah. How long
rule?
before they run?
Okay.
So I think where I was getting to is, since they seem to be prepared and they were coordinated in the way they were asking their questions, I think the decision is going to come down sooner rather than later. I wouldn't surprise me if it comes down in a month or 2 or 3 even. It may take longer, but I don't know how long this court usually takes to render a decision. But I think it's going to come down sooner than you think.
Okay. All right. Professor, thank you very much.
Oh, my pleasure. Very interesting.
Interesting stuff. We will talk soon. Off he goes. And there is another Murdaugh development that we need to tell you about.
So Buster Murdaugh has settled his federal court defamation claim. This was against Warner Brothers, and it included 2 documentaries, Murdaugh, Deadly Dynasty, and Low Country, The Murdaugh Dynasty. I think one of those was HBO. And Buster kind of contended that he was inaccurately portrayed as the killer of Stephen Smith in both of these documentaries. Now, the Netflix documentary is still pending in state court, so that one has not settled, but looks like the federal one has settled. People keep asking me if I know how much money he received. I do not. I'm assuming probably non-disclosures.
Yeah, I would have bet non-disclosures.
Or probably signed.
Right. And another note, this was posted on our Impact of Influence Facebook page. You should go there. And SC listeners, please consider contacting your local representative. These are 2 bills that could significantly improve safety and response by emergency services in South Carolina. H. 3602, Jaden's Law. The bill was drafted after a fatal 2020 boating incident exposed deep cracks in emergency response and investigative procedures on South Carolina waterways. H3522 and S455. These are companion bills aimed at making non-fatal strangulation a standalone felony, a charge advocates say it is long overdue in a state that's reportedly been called out as the last national holdout. We've done a few episodes on the tragic story of Jaden's death, and thanks to Jen Wood of FITS for bringing that to our attention. And you can find out on the Impact of Influence Facebook page. It was posted the beginning of February. You can find it there.
Yep.
All right. We are part of the Evergreen Podcast Company. When you go to the YouTube channel, hit subscribe. We're always grateful. Talk soon, friend.